Welcome back to the Schiller Hamilton Podcast. I'm Derek Harper, one of the attorneys here at our firm. I'm here with Charlie Corrigan, another one of our attorneys, and we're going to discuss a pretty common practice area that we see, which would be premises liability.
Right.
Okay. A lot of times people may know it as slip and fall, although it does have other types of cases that occur other than, someone falling due to something on a floor or some situation like that. Yeah. So let's just kind of get started, kind of explain what does a premises liability case mean, to everyone watching and listening other than our terms.
Yeah. Pretty much just like you said, it's generally referred to as slip and fall. Basically what it means is when someone is injured in their capacity as a guest, just generally speaking, whether, and we're going to get into this a little bit more, but whether they're a guest at someone's house or at a business, a shopping center, slip and fall, generally speaking. Premise liability means that the owner of the premise is liable for something that they did negligently and cause injury.
Okay. So pretty much whenever some injury happens to someone on a piece of property is when we deal with a premises liability
right.
case.
That's the first step in, bringing a case and seeing if they did anything wrong.
Okay.
If they yes.
Okay. So, obviously we're not going to get too much into what builds a negligence case or a personal injury case, but obviously there is some sort of duty owed to someone,
right,
which is then breached. So, we know, that the biggest difference is how you are classified.
Yeah.
So why don't you tell everybody kind of what that means as to the levels of classification of a guest on a property, and what that means for a personal injury case?
Yeah. So the three general categories are your status as a guest on property, just a person on property is you're either a trespasser or you're a licensee or an invitee. We don't really need to talk about being a trespasser for obvious reasons, but a licensee just thinks social guest. That's generally speaking, when you're going over to a buddy's house or you're going to a little get together, that's your status as a licensee. And as an invitee, think business visitor. So basically, an invitee is whenever it could be a contractor going to someone's house. Probably the most common example is it's a customer at a store or some kind of business. But and it's basically you're an invitee when there's a mutual benefit between the visitor and the host of the visitor. So for example, when you're at a store, even if you don't end up buying anything, theoretically, you're there to provide a benefit to the store via your money, and they're there to provide a benefit to you should you want it, which is whatever you want to buy. And another form of being an invitee is when you're a public guest. So it doesn't necessarily have to be an exchange of goods. So think maybe you're at a local fair that doesn't charge for entrance. Maybe you're at a museum that's free. You still have the status of an invitee. So general terms, think social guest and think business guest.
Okay.
And I'm sure you're going to ask me this next, so I'll go ahead and go into it. The reason why that distinction is so important is the different duties owed to those different classifications. The duty that a landowner or owner of property owes to a social guest really comes down to, and I guess in practical terms, not doing anything just ridiculously dangerous. That's, just pretty much inexcusable. And other than that, the duty is to warn of latent defects, so hidden defects, and which is obviously a pretty low duty. I mean, that's a low bar. For someone to be held liable as a host, there either has to be something dangerous that they knew about, essentially, or very strongly should have known about. Just it's inexcusable they didn't know about it and they didn't tell you. Mm-hmm. That's pretty much where liability exists for social guests.
Okay.
Yeah. So, and then for the liability for a landowner, business owner, for example, to an invitee is essentially a duty of exercising reasonable care, which consists of keeping the premise in a reasonably safe condition, which means that the duty to warn of dangerous conditions that they know or should know about, and to prevent or to not do activities on their land that they know or should have known create an unreasonable risk of harm to the invitee. So it's a pretty big difference there, obviously. If there's a hidden defect, an invitee, clearly there's liability there, but it doesn't even have to be, it's more than that. It's not a full affirmative duty, which we'll go into a little bit more, but basically, as an invitee, there's an expectation that the landowner or premise, whoever runs the premise, is aware that people will be coming in, people who may have never been there before, people who enter a store, a business, a contractor who goes to a home or property to work on the home or property. There's an there's an imputed legal understanding that the owner of this property should know that the invitee has the right to expect that there's no reason to think that they're danger, that there are dangers present. They're not required to, their concern is to do their job, to look for products, pay for the products, do their contracting gig. It's not to be incredibly paranoid about,
Imagine walking through a grocery store and be constantly looking for pitfalls.
Exactly.
Where you could fall. Yeah.
Exactly.
Well, how about, there's a lot of stuff you just said. We talked about how there's different duties of care, about whether a danger is hidden or latent, or if it's obvious or out in the open. So why don't you give everyone a basic example of like a business guest or an invitee case, and then maybe a basic example of a social guest case. What's something that people may have heard of happening where they can understand what we're talking about?
So probably the best example of a social guest, a strong or at least plausible case of liability. Again, it's really difficult, but. So you go over to someone's house and you're having a good time, and let's just say in this example, okay, so there are stairs from the first floor to the second floor without a railing. Okay, so that's not latent. You see that immediately, and really they don't even have to point it out to you. But either way, so that can be there. But let's just say in the same situation, there's no railing, but you say, hey, can I go to the bathroom? Yeah, man, it's, right there. You walk into the bathroom and, immediately first step, you step in a hole.
Okay.
So that was latent because it wasn't obvious. Whereas if right before you are about to go to the bathroom, you say, oh, wait, let me go run upstairs and get something, and you fall off the side of the stairs, it's a trickier case. So that's just that's like that juxtaposition is kind of shows how difficult it is, and it's kind of, I don't know, it's a little bit.
You said something about a hole, and it made me think of the movie when we were kids, Home Alone 2.
Yeah.
He's in that house that's being renovated.
Yeah, those were right.
And there's a gigantic hole in the floor.
Full of weight.
Right when they open the door. So, like, if you invited someone over to your house and you failed to mention the fact that, oh, yes, I have no floor when you walk in, that's going to be pretty clear.
Yeah, Home Alone, those were all latent dangers.
Yes, you did not warn someone of those dangers.
Yeah, what was the name of his family?
The McAllisters.
The McAllisters would be in trouble for that.
Certainly. Okay.
Well, but they would also be trespassers, but let's not even
We won't get into trespassers. Trespassers is a whole different, kind of animal.
Yeah.
And it doesn't happen very often, and there's not a lot of rights that you have as a trespasser, so we won't really touch that.
Right.
So give us kind of that basic example of a business guest or an invitee.
Yeah, so just think going to a store, essentially. Maybe you're going to a museum where a free museum. You're going to an event, a local event held by local government. Maybe, even charity programs. I mean, don't sue charities unless you have to, because it's good what they do. But I'm just giving that as an example. But really think stores. Think shopping malls, stores.
What happens to the person that would cause a case that would be a kind of, a basic example of a case.
Yeah. So especially when it comes to the most common premise liability cases, slip and falls, let's just call them for our purposes, is you go into a store as a customer and you're just doing your thing, you're shopping. Like we talked about, there's no legal duty to be paranoid that, something terrible is going to happen. You just are minding your own business, looking to see what you want to buy. And either the two general classifications are foreign substances. A foreign substance causes you to fall. So basically, foreign substance essentially just means something is really on the floor that isn't supposed to be. Let's just say there's produce from, left side of the store that's on the right side of the store, or there's water somewhere, or even like an item that's on the floor. So basically that's kind of a general category.
So something's on the floor.
Something's on the floor, right?
And I think back to law school and those classic banana peel cases.
Yeah, banana peel.
That kind of, and you think of cartoons and everything of someone slipping on a banana peel, but those actually are some of the things that established some of the things we have now,
right?
About notice and things. And I know we'll get into that.
Yeah.
So just for everyone listening and watching, for business guests, just to recap, you're going into someplace that you're benefiting them, like you said, maybe a public place, or it's going to be a business, usually Walmart, grocery store, and they're walking around doing their shopping, minding their business, and they fall on something,
right?
Whether that be, like I said, a banana peel, water, some other product on the floor. And then social guests, we talked about, you go into someone's house and there's something there that you had no clue would ever be there, but the homeowner knew. So that's kind of our basic thing. So that kind of gives everybody an example of what we're talking about.
Right. And then the other category, just think, invitee in a store is kind of dangerous condition.
Okay, yeah.
So the duty, the way that liability occurs in both situations is there's the foreign substance is also considered a dangerous condition. So for both, there's a dangerous condition that the store, which its employees, the knowledge is imputed to the store. So that the store, by and through its employees, knew or should have known there was a dangerous condition, or the store, again, by and through its employees or agents, themselves create a dangerous condition. So a dangerous condition, foreign substance aside, think using a cheap product to wax a floor to clean it. A mat that as soon as you step on it, it just slides. Okay. Any number of things. There's, maybe there's a nail or some kind of a permanent fixture. It's not just like something on this shelf, fell and ended up being here. It's like, it's a situation where this was a condition that was there. It's not like it just happened. And the reason why that distinction is kind of important is because foreign substance cases really, it's as simple as this. Liability really comes down to just this. There has to be some evidence, and can the person injured show some evidence of how long that item was on the floor? Whereas in a dangerous condition case, generally, it comes down to, well, one caveat is, or can they show that a store employee put that foreign substance there, which is obviously difficult to prove. And dangerous condition, it's basically just, it comes down, it's not really a time issue. It's just, did they know about it, or should they have known about it? When they ordered this mat, maybe they got it for a little cheaper. Did they test it out? Did they know this thing was just going to fly up and you were going to slam your head the second you walked over it? Is the tile itself that they used, was there issues with that? Was there a for lack of better terms, janky shelf holding lumber that just it was just imminent to one of the pieces to slide over and just knock you on the head? So that's kind of the major distinction between the two. And in my experience, foreign substance cases it's much more of a challenge to establish liability.
And what this comes down to really is their knowledge. So for a foreign substance, what you were kind of getting at there is the timeline kind of establishes, did they know or should they have known with reasonable inspection that this thing existed on the floor?
Right.
So like we said, a classic banana peel, example of a banana peel falling from a produce stand in the produce aisle. If that area is normally, people, associates, personnel, whatever, around that area for a significant period of time that they should have seen it, then that would establish that they had knowledge it was there.
Right.
And then obviously when you're talking about a dangerous condition that was created by the property owner, we have to have kind of a reasonableness standard of is it reasonable to believe that what they did would cause someone to be injured?
Right.
So, you said the example of someone waxing floors or mopping floors. Well, it's pretty reasonable to understand that someone could easily fall. That's why most of the time when we see someone mopping up clean up on aisle 3, there's a wet floor sign. So they're taking that step to warn people about the fact that we're creating this dangerous condition. We know it's dangerous. We're warning you.
Right.
And then, so it really just comes down to proving that knowledge.
Right.
And there's a big key thing of reasonableness and knowledge. And so we have to be able to prove that would a reasonable person working there should have seen it, or would it be reasonable to know that business knows that what they just did created a dangerous condition. Right.
And an adequate warning is almost a complete defense. Cones, when it's clear even to a customer, who there's no reason to expect there's any dangers that would happen while they're just going shopping for dinner for the night or what have you. A lot of it does come down to warning. Even with an invitee, if there's something dangerous, and there's a fair warning, that's a complete defense. Now, with dangerous conditions, you can't just. Let me put it this way. Here's and I guess an exception to that. If you use tiles that are terrible to save money, and it's pretty reasonable to think that they'll cause people to wipe out, you can't just put a little sticker on the front of the store like, "Hey guys, just make sure you're careful when you're walking." So it has to be an adequate warning, and it can't be a warning to just completely get them off the hook for any responsibility to exercise reasonable care. So like we've been talking about, it really just comes down to ordinary care. The duty of care is to exercise reasonable care.
But we do see, I see it anyway. We do see responsible business owners who say if it's raining, just right out of the gate, before anything ever happens, there's a wet floor sign when you walk in.
Oh, yeah.
Because they know people are walking in with wet feet. There's probably going to be water here.
Right.
It's going to create that dangerous situation. So they kind of are very proactive.
Right.
And they're doing what they should do.
Yeah.
Warn everyone to say, hey, you may not have realized when you just walked out of the rain, but the water, could be on the floor.
Exactly.
And just be careful.
Exactly.
But on the other end of the spectrum, we see way too many times business owners or business managers, at least, who do not take that step.
Right.
And they just kind of leave things out there.
Yeah.
So, we've kind of talked about what we have to prove there. So kind of like go into how do we prove that knowledge? Now, you talked about time of something on the floor, or if we have a dangerous condition that was created by the business or the property owner, how do we go about proving those cases?
Yeah. So the first thing that you need to try to do is, let's talk foreign substance cases.
Okay.
Is get a hold of video footage. I mean, right off the bat, you need to either, you need to make sure that video footage is preserved, because pretty much every business in the course of business, they delete footage. And this is assuming that the cameras are rolling to begin with, which is another issue. And it's not malicious. It's data cost of just saving every second of footage forever and eternity is high. So if they're not on notice of what happened, and you don't inform them, hey, listen, you need to preserve this video footage, and you don't try to get that video footage, if a month later they say they don't have it,
Well, I get it, because a lot of times that's our best evidence. Like you said,
totally.
Any business is going to have CCTV.
Yeah.
Any retail business anyway.
Yeah.
It's part of how they stop shoplifting and things like that.
Yeah. But yes. So to get back to what you were asking, that's primarily a way to prove length of time, because again, the whole theory, the whole length of time issue is basically the courts. I mean, it's precedent at this point over and over again in Supreme Court opinions. A store is not an insurer of safety.
Mm-hmm.
They don't insure your safety. That's not their responsibility. In other words, at a big store, there was something on the ground and it may have been there for a minute, it may have been there for 30 seconds, it may have been there for an hour. But if you can't show an amount of time, then we're not going to hold this business responsible. We're not going to impose a duty for them to have 100 employees stationed every 5 feet from each other, just scanning constantly. So that's the whole theory behind you have to show some amount of time, because at some point, they aren't an insurer of your safety. Stuff happens. And another thing to keep in mind is another challenge is there is a duty of reasonableness generally, but there's no duty to keep sweep logs. So there's no duty to say, Joe Smith at 11:45 walked by aisle 7, we're good to go. Like, there's no duty to do that. So evidence could come in the form of, getting names of who was there, employees. Maybe someone said to said to the store, hey, I think there's something on the ground there. That kind of thing. But another thing that you'll want to do is you're going to want to get evidence from the store or the business. You want to get their training policies, if they were trained on procedures to make these events less likely, and it would,
But what they will do is it's critical too that person, say if they slipped and fell and they were able to get up and they walked over to customer service, they need to know exactly where this happened.
Right.
Because Walmart specifically is only going to probably preserve the nearest camera.
Yes.
And so if something happens and you say I was on aisle 2 and you were really on aisle 2 in the grocery department,
mm-hmm.
there's maybe a difference there.
Right.
So just trying to get that information to the store
mm-hmm.
so that they can fill out their procedures.
Yeah.
But then also I would say you should at least talk to an attorney.
Yes.
Because if you do have that case and we do want to preserve the evidence properly, we need to do that in a timely manner.
Yeah.
And it needs to happen immediately.
Exactly. It really does. And it sounds self-serving, but it just couldn't be more true. It's
even if you don't
with
plan.
car accident cases, it's not the case with a bunch of different just categories of cases, but with this specifically, it really is like there's a clock that is running. But even a little bit down the line, for either situation, you're going to want to get internal documents from policies, procedures, how many employees were there, who was the manager on site, how long had that person been a manager, what was their qualifications, that sort of thing. But yeah, so a lot of the information that will really help you not only just prove your case, even just you've been heard the story, you want to know what did they do, how much should they be held responsible. You'll just want to know if you got hurt at a certain place, so it'll help you know that as well. But anyways, all of these pretty much they have possession of the information that you need. They just do. So whether it's through discovery once the lawsuit is filed, whether or before a lawsuit is filed, you tell them to preserve evidence, and you ask for these policies and procedures. They may or may not give them to you, but down the line, if you need to get them, with an attorney, you will get those documents through discovery eventually, subpoena power, once a lawsuit is filed, etc.
But the problem is like you said, if they're not preserved, they're not going to be there to be to get later.
Exactly. Exactly.
So kind of while we're on that topic then, what's some other reasons that having counsel or having an attorney can really help your case like this? Like, are there defenses that people try to use or
mm-hmm.
businesses try to use? And how can an attorney help to get around those type things? What are some common things that they use to try to defeat these kind of claims?
Mm-hmm.
And then how can an attorney help? We've already talked about how, an attorney can help preserve the evidence properly. Right. But let's talk about that. Like, what's some things that are used to try to defeat these cases or these claims, and how an attorney can help fight that battle?
Right. So pretty much, I don't need to go much more into this because it's essentially what we've been talking about this whole time, is their first argument is going to be prove it. Okay. There's insufficient evidence there.
So we got that one. Check.
All you can show this happened, which as we discussed, unfortunately, it's just not enough. The fact that something happened in itself is not enough to impute fault to the landowner or storekeeper. So another major defense that is pretty common is that the dangerous condition was open and obvious.
Okay.
So what that means is essentially it's the argument that, before even getting into, speaking from the perspective of the defendant or at-fault party, before even getting into what we knew, what we should have known, what we did, what we should have done, this dangerous condition, you should have known about it because for a foreign object on the floor, if you were looking down, you would have been able to see it. And we think you were, kind of gazing around. You weren't paying enough attention. With a raised sidewalk, we think that you should have been looking at the ground when you walk, something along those lines. So open, they might not even say it to you if you don't have an attorney. They'll just summarily say, sorry, can't help you. Have a good day. But one of the quiet part that what they're thinking is open and obvious possibly. And some ways to get around this are the argument that even when something is open and obvious, which, your attorney will need to make efforts to prove that it wasn't. Mm-hmm. Because open and obvious needs to be open and obvious. And if there's an assertion that it was open and obvious, then they need it almost kind of shifts the burden. They need to show that it was really open and really obvious. But anyways, a way to counter that argument is that essentially landowners or merchants, stores, they can't use the argument of open and obvious successfully if there are circumstances surrounding the incident, such as the common age of some of their guests, maybe disabilities, whether the guests will be distracted or not, and just in general, the entirety of the circumstances surrounding the event, it precludes them from using that as a defense. So anyways, open and obvious is a huge defense. And other than that, it's basically saying you haven't met your burden. You haven't shown that we knew or should have known about this danger that we caused the danger, or that we were failing to exercise reasonable care, just the ordinary care that a store owner ought to exercise. So,
and like you were saying, a lot of that, it seems like it comes down to the person. Like you said,
right.
If there's a gigantic pothole in the middle of a parking aisle at, again, Walmart. Again,
right.
We're not picking on Walmart, I promise.
Yeah, it's just
Target.
If there's a big hole at Target.
Yeah. In the driveway or in the aisle of a parking lot, it's going to depend, like you said, the age of the person, how much stuff's going on that may distract them. Is it their own, their local store,
mm-hmm.
or is it a store from, are they visiting?
Right.
Are you at the beach?
Right.
There's all different things that go into that, but that is probably the most common, I agree, is the open and obvious. Other than attacking, like you said, the actual existence of an item or foreign substance, mm-hmm. or the knowledge of it being there.
Right.
Open and obvious is kind of what we see the most.
Yeah.
But there's ways around it. And
yes.
Like I said, that's another reason why it's important that if something like this happens to you, whether or not you think you would file a claim or not, just talking to an attorney,
right,
and just seeing, because, like I said, there's so many pitfalls that could happen. Mm-hmm. And I hate to use that word since we're talking about slip and falls, but for sure, after you get through the slip and fall, there are more things that could trip you up.
Right.
And
let me also mention one additional area of liability that is less common, but it does happen. So another area of liability, just in case, just to put it out there, because this does happen, is the liability of a landowner from a criminal act from a third party that occurs on their premise. So, the duty to exercise reasonable and ordinary care towards the safety of your customers extends to using ordinary and reasonable care and putting forth reasonable measures considering the circumstances to prevent foreseeable crime. Now, if there's a fight, if you get injured at a store or a restaurant, just you name it, then definitely see an attorney to get advice on what you want to do, because and a challenge in those cases, like we talked about, it's very circumstance dependent. But you're going to want to get an attorney because you want to have interviews or during litigation depositions about whether this was foreseeable. Has this ever happened before?
Yeah, because most of those cases are going to fail. But you never know.
What were your security measures? If you're how much alcohol was being served to the guests?
Yeah, and that's getting into a whole different.
But that's also, and that is probably a topic for another time. But that's something to keep in mind, that just the duty of landowners, stores, museums, whatever. Also, in that realm of the duty to exercise ordinary and reasonable care is the duty to prevent foreseeable crime from third parties. So it doesn't have to be a store employee, just the duty to prevent you being injured by a third party on their premise. So, I mean, that's worth mentioning at least, even though it's not exactly what we've been talking about specifically.
Well, I mean, I think that kind of covers, like I said, we really wanted to talk about slip and falls. When
we
talk about, types of cases, there's obviously large, categories of cases such as premises liability, but the vast majority of those happen to be slip and falls.
The vast majority, yes.
Slip and fall accidents. So
Definitely.
I'm glad that we could discuss that a little bit more, and I thank you for coming on and kind of telling everybody about that. I think you have a blog post on our website about this too, or it should be on there soon. So if anyone has any more questions, they can obviously get on our website and go through our blogs and find some more information. And I want to thank everybody for watching and listening. If you or anyone has ever had a case like this or had an injury, at a public place or at a business, please give us a call for a free consultation, and we can at least review your case and make sure that you have everything that you need, and we'll have your back if necessary. So, thanks.
Yeah, thank you.